But that begs a massive question, my lady, which is, government's had 25 years to investigate, and it hasn't done so. Why should the applicants be forced to delay now so that government can finally start investigating something it should have investigated 25 years ago? It goes even further. Your ladyship asked my learned friend, how many families are we talking about in this case? 22, said my learned friend. Well, leave aside the last 25 years. This application was launched 6 months ago. In 6 months, you can investigate 22 files if you have the desire to do so. Why hasn't government 6 months down the line been able to determine whether there was interference in any one of the 22 files relevant to the applicants?
So the documents should be easily available or not accessible?
Well, one doesn't know, but if government says, look, a very complicated issue because we've tried and we addressed these inquiries in relation to the first applicant in the case of the Craddock 4. In the case of the Craddock 4, one would imagine is self-evident. But assume government said, well, let's take the 15th applicant. We tried our best, but, the documents seem to have disappeared. But there's nothing of that before your ladyship on the papers. What there seems to be before your ladyship on the papers is the complete absence of any effort to get to the bottom of why these victims, in respect of whom these 22 families seek redress, why their cases were never investigated and prosecuted. There is no evidence of that nature, and one has to assume that after 6 months, one could have at least come up with a position in respect of some of these applicants. There was interference, there wasn't. It's not like the members of the prosecution service who were tasked with doing these investigations are closing ranks and saying, I invoking my right to silence, I don't want to say anything about this for fear of incriminating myself. They're going on oath and saying, yes, this investigation was killed because of this, or there's no suggestion that any of these prosecutors, Ackerman, Pretorius, even Nuka, who was in charge of the prosecution service, have even been approached to find out. You say that there was interference. Well, was there any interference in this case? What was the interference? How did it? Nothing of that nature. There has been no attempt to investigate. And you can't choose not to investigate, first for 25 years, then for 6 months after an application is launched, and then say to the court, well, please put this application on ice because it's politically awkward for us to take a position. And that political awkwardness is essentially self-created because we haven't bothered to investigate the facts ourselves, even in the 6 months since the application was launched. Milady, to get then to the papers and the individual applicants' cases, and why delay...
I think the point cannot be disputed, that these applicants have been waiting and they're getting older and so forth. That point in the stay application having been made, is it necessary to go to individual applicants at this stage?
Well, can I just give your ladyship a couple of examples? I mean, on the papers, your ladyship will see that a grandmother in whose home one of the murdered victims grew up is now 92 years old. Now, at 92, a stay of a year attracts a significance that it doesn't attract at 21. The reference there, your ladyship, is in respect of the 18th applicant. It's page 001-1109, paragraph 19.
Thank you.
But there are a succession of, if your ladyship reads the individual applicant stories, almost without exception, they speak of parents siblings who have pursued this cause and who have died. And the applicants, many of the applicants say, I am the sole surviving child of, or I am the mother of. My husband sought justice all his life, but he passed away in. That is a recurrent theme of this. I don't want to belabor the point, and I don't need to take your ladyship to a succession of references, but if your ladyship reads those individual affidavits of the individual applicants, one sees the story again and again and again. And that story just emphasizes how critical it is for the applicants to have their day in court as soon as possible, and for the stay, and for these proceedings not to be stayed indefinitely. Milady, I've already addressed your ladyship on the uncertainties relating to a commission of inquiry. It's a topic we address in the heads from page 201 onwards. Don't want to repeat my submissions in that regard. I've also addressed your ladyship on the unconstitutionality of the stay application. It's addressed in the heads from paragraph 55 at 005208. Just want to emphasize one submission in that regard, which is...
Because it is an important legal concept or legal principle.
Indeed, my lady, it's about the separation of powers. And we've already emphasized that the function of the court is to decide disputes. It's not to accommodate the political convenience of the head of state. That's offensive to the separation of powers and the independence of the judiciary. But if one goes to paragraph 16 of the founding affidavit in the stay application, one sees another element of judicial independence being brought into play. What the President's deponent says at paragraph 16 is the following, and we quote it at paragraph 55 of the heads. Government and the President, supported by the rest of the respondents, submit that establishing the Commission has the following consequences. 16.1. Whether there was interference and collusion by whom and which investigations and prosecutions were interfered with should be decided by the Commission. 16.2. A conclusion of unlawful interference and collusion can only be properly drawn after a commission has heard and considered all the evidence. And this, with respect, is the executive telling the judiciary how it is to exercise the judicial function. You can only properly do your job as a court after the commission. That, with respect, is not something that the executive is allowed to do under our constitution. It can't tell a court how or when to exercise its judicial function. So, while we submit that even on ordinary principles outside the context of constitutional issues, there's no case for a stay, there is a very, very important constitutional point here, which is this stay is being brought by the executive in an attempt to tell the judiciary how to exercise its judicial function so as to accommodate the political convenience of the executive. That is fundamentally offensive to the separation of powers, to the independence of the judiciary. Milady, that concludes our submissions. We would ask your ladyship to dismiss this application for a stay and to do so with the costs of due counsel. Thank you.
Yes, in reply.
Lady, can we start by dispelling this notion that the reason that the President and the government want a stay is because they shy away from making awkward political decisions? That was not the submission when I addressed my lady. My lady will recall how that occurred. It occurred in this context. My lady asked why don't the President and the government simply oppose the case on the founding affidavit as it stands? If the President and the government say there isn't a case made out there, there are no facts of interference and collusion. But what I said to my lady is primarily that is not in the interest of justice, because it is not in the interest of justice for the President and the government to say to families who do this in a notice of motion. One, they ask for a commission of inquiry. Well, actually, it's the other way around. One, they ask for a finding of unlawfulness and constitutional damages. Two, they ask for a commission of inquiry to establish the facts from which findings of unlawfulness are to be made, because they say categorically that that is what the Commission must establish in the affidavit in the stay application. In the affidavit in the main application, and they repeat that in the stay. So my lady, what we say is this is not a case. What our learned friends are doing is concocting separation of powers sort of disputes where they don't exist. There is no separation of powers dispute here. All the President and the government asked is, as they're entitled to do, where they are before the High Court, and they asked the High Court to exercise its inherent powers to regulate its own proceedings by staying the main application. And the reason, we come back to this, my lady, there's an inherent dilemma in the notice of motion and the founding affidavit. The applicants want a commission of inquiry to establish the facts, the true facts. And on the other hand, they also want to sue for unlawfulness and damages where there aren't true facts. I mean, that's the problem.
Well, that is sort of the view of your clients. It appears to me that the applicants and their legal team might have slightly different taking on there are no facts.
Well, then why is there, forgive me, my lady, sorry.
No, that was my point.
I'm sorry, I jumped the gun a little bit. Well, why is there a need for a commission? I mean, that's the point. We know why they're asking for a commission, because we don't know the true facts here. And it doesn't help to say, well, there's been this long delay. Why couldn't they have investigated in all this time? There hasn't been an investigation. Well, there have been. In fact, the families say that they don't want internal inquiries. They make that quite clear. They don't want internal inquiries. They object to them, and that's also why they call for an independent commission of inquiry, which, by the way, isn't advisory. The findings of the commission are effective in administrative law. They stand until set aside. So the idea that what the commission will do is advise the President isn't correct at all. If my lady sits, as my lady could, as the chair of a commission of inquiry, she's not advising the government. You might have been appointed by the President, but you're exercising your powers, your investigative, your adjudicative powers, in the context of a commission of inquiry. So my lady...
And that is akin then to administrative action.
Yeah, correct. And what the applicant's
Just a
court...
moment.
Sorry, my lady.
And the court will be bound by those.
Yeah, but the findings, yes. Of course it will be bound by the findings. I mean, you can have them set aside on review, but until then, those findings bind everybody. Oh, I see. Oh, sorry. They bind the parties.
Yes. No, I
Yes,
thought
good.
maybe
No,
a question mark.
No, they
the
bind the
court
parties.
is not bound. It might bind the parties, but the court is not bound by that.
Yes, but the decision stands until set aside. The findings, I beg your pardon, stand until set aside. So
in that sense, the court is bound.
yes. The courts set aside administrative decisions, but until they're set aside, well, everybody lives by them. I mean, you...
No. Uitekram.
Yes. Correct. So my lady, the difficulty that the President and the government have is this. When you apply to court, and you seek both the commission to establish the true facts, and you also want a court to find unlawfulness and damages on facts that are still to be determined, then the President and the government say, well, you can't do that. You've got to stay the one so that the other can run its course, because we all agree that it's got to run its course. They talk about delays. They say themselves, that's the families in the papers, they say that this is very different to the state capture inquiry. This is a limited inquiry and it should take, they say, no longer than 6 months. So they themselves say, look, we don't anticipate that there should be a delay. Do delays happen? Yes, they do.
It seems to me that if one has regard to the relief set out, the primary relief is the declaration of unlawfulness and then the constitutional damages. And then we only get the commission in press 6.
Correct.
So it seems to me that when this application was prepared and drafted, because one normally, what you want, your chief relief, one would set out pre 1 and so forth.
But let's, and I took my lady through that. If my lady, which she will, look at particularly the founding affidavit in the main application, and ask itself, my lady asks herself, why do they want a commission of inquiry? It's to establish the facts which are important for unlawfulness. That's the dilemma. So that's why we submit that my lady can exercise her inherent jurisdiction to stay. Now, what my lady was told was that the authorities are against us. We refer in one of the decisions referred is the Mapanga decision, and it's in the bundle of authorities. And in that decision, the court wasn't dealing there. A stay didn't happen in the context of either an arbitration or another court proceeding. And in fact, in Caesarstone, the court proceeding was in a magistrate's court in Israel, which I doubt binds the high courts here. But it was in a magistrate's court in Israel where the litigant said, "We'll stay this until that's decided." So my lady, the idea that the authorities say that my lady can only exercise her discretion in the limited context.
No, I do not think, because it can never be limited. Yes. Otherwise, there isn't a discretion.
Correct.
I think one is just looking for maybe examples of previous cases. I'm aware of the Mapanga matter, and that was also legal proceedings whether it would be binding, but I hear you.
Yes, and in Mapanga they stayed the eviction application in the High Court until Miramotu, by the way, the court did, and it said, well, you must go. And there, one of the litigants who was sought to be evicted had not gone to the rental tribunal, and the court said, I'm going to stay this until you do all of that. Hadn't even done that at the time, and did so Miramotu. The Constitutional Court, as we understand it, held that was permissible. So the notion that the authorities are against my lady exercising her discretion in this context is not a sound one, because there are authorities that say that my lady can. Then my lady, what we did not do was we did not remind my lady that we also seek reinstatement of those.
Oh, I do not think that is, as I've read the papers, the applicants are not, the respondents are not opposed.
The reinstatement is not in this.
So thank you for pointing that out. I do not have a problem with granting the reinstatement relief.
I didn't ask for it, my lady. I got so excited about the argument.
It's a very interesting argument.
Yes, it is a more interesting argument. So we understand. No, our learned friends have not opposed it. I just didn't. We never asked my lady to. We never reminded my lady that is one of the orders that is sought. Could I just check with my learned Judy if there's anything else? Those are submissions.
Thank you.
Milady,
Just also there's one thing I never understood. And is that, legally speaking, the findings of the commission, is that akin to administrative action?
That is why I stood up.
I was quite surprised.
And it's quite clear that it's not, my lady. And with respect, the leading passage of the Constitutional Court, the most recent decision of the Constitutional Court in this regard is cited at page 005-202 of our heads, paragraph 40. It's what the Constitutional court said in the State Capture Commission case, and quoting from what the Constitutional Court had said previously in the SAFU Commission case. And there, in state capture, in the passage reproduced at paragraph 40, the Constitutional Court said, notably in SAFU 3, it was emphasized that, and we've underlined it in our heads, the findings and recommendations made by a commission established in terms of Section 84(2)(f do not bind the President. The President is free to reject them in their entirety. And then it quoted from SAFU. In the case of the appointment of commissions of inquiry, it's well established that the functions of a commission of inquiry are to determine facts and to advise the President through the making of recommendations.
That's the word that I use. So.
Indeed, and the court emphasized the President is bound neither to accept the Commission's factual findings, nor is he or she bound to follow its recommendations.
But the courts are bound by that.
No,
not the President.
No. The President
it's just in jest.
Nobody is bound. The only function of the Commission is to advise the President.
That's the way I understood it always.
This is not. I think, with respect, my learned friend is conflating principles relating to a decision of the Public Protector or a report of the Public Protector or another Chapter 9 institution with reports of a Commission of Inquiry. They are purely advisory, purely for the benefit of the President, who may choose to accept them or reject them at his will, both the findings of fact and the recommendations. And a court is completely unbound by them because a court is, it would be improper with respect for a court to have regard to evidence and findings in a collateral proceeding for the purposes of a decision in a matter where that court has to decide the issue on the basis of the evidence before it. But in relation to the status of a commission, the law is absolutely clear from the Constitutional Court in those two judgments cited in paragraph 45. It's purely advisory, not binding on anyone.
Thank you. Well, I've been thinking while I read the papers and listening to the submissions, it's very interesting. I mean, it's an interesting matter to me. And I think on a lighter note, all I want to say is I am glad I'm a judge and not the President. Judgment is reserved, court will adjourn.
Let's not hold our breath.